Congress just permanently eliminated suppressor and SBR taxes for the first time in 90 years. But anti-gun politicians immediately responded with a counterbill to resurrect the tax at $5,500 per stamp. Subscribe and hit the bell right now, because what happens next will determine whether average Americans keep this historic victory or lose it forever. The historic congressional victory. What just passed through Congress represents the most significant rollback of federal firearm restrictions since the National Firearms Act was originally enacted in 1934. The legislation doesn't simply reduce the NFA tax temporarily through budget adjustments. It creates a permanent statutory prohibition, preventing any federal agency from collecting transfer or manufacturing taxes on suppressors and short-barreled rifles. This means the Bureau of Alcohol, Tobacco, Firearms, and Explosives can no longer collect the $200 stamp that has generated over $340 million in revenue since 2000 alone. The bill received support from 218 representatives and 52 senators, representing states where over 190 million Americans live. You have representatives from purple districts who just put their names on legislation that permanently blocks a revenue stream the ATF has relied on for decades. The legislative language is ironclad. It explicitly states no executive order, no agency regulation, and no future appropriations bill can reinstate this tax without completely new legislation passing both chambers and getting a presidential signature. Here's what makes this even more powerful. The effective date is immediate. The moment the president signed this into law, every pending Form 4 application for suppressors and SBRs that hadn't been processed yet automatically became tax-free. The ATF is currently sitting on approximately 43,000 pending applications that people paid $200 for, and now those applicants are entitled to full refunds. But there's something happening behind the scenes at the ATF that nobody's talking about, and it could unravel everything. The ATF's internal crisis. Inside the Bureau of Alcohol, Tobacco, Firearms, and Explosives right now, there's complete chaos over how to handle this permanent tax elimination. According to internal documents obtained through Freedom of Information Act requests, the ATF's NFA division has seen processing times collapse from an average of 240 days down to just 14 days for new applications. Because without the tax to process and verify, the entire justification for their months-long waiting periods has evaporated. The ATF currently employs 287 personnel, whose primary job function involves processing NFA tax stamps and maintaining the National Firearms Registration and Transfer Record. That's 287 federal employees whose entire job description just became irrelevant overnight. The agency is facing a budget crisis because Congress allocated $34 million specifically for NFA tax stamp processing in the current fiscal year, and now that money has no legal purpose. Federal agencies can't just reprogram funding to different purposes without congressional approval, which means the ATF is sitting on millions of dollars it legally cannot spend while simultaneously employing hundreds of people who no longer have valid work assignments. Here's the part that should terrify every gun owner. The ATF is currently exploring whether they can impose administrative processing fees to replace the eliminated tax. They're arguing that even though they can't collect a transfer tax, they could potentially charge applicants for the cost of running background checks and maintaining the registry. But the real bombshell is what major gun rights organizations are doing in response to all of this. The 15-state coalition lawsuit. 15 state attorneys general have joined forces with Gun Owners of America, the Firearms Regulatory Accountability Coalition, and Silencer Shop in what's become the largest coordinated legal challenge to the National Firearms Act in history. These states, including Texas, Florida, Montana, Wyoming, and 11 others, represent over 125 million Americans and collectively account for 61% of all suppressor ownership in the United States. The lawsuit's core argument is brilliant in its simplicity. The Supreme Court upheld the NFA in 1939 specifically because it was a revenue measure protected under Congress's taxing power. When you remove the tax permanently, you remove the constitutional foundation. The government can't claim this is about generating revenue when there's no revenue to generate. What makes this lawsuit particularly dangerous for the government is the timeline. The plaintiffs filed a motion for summary judgment, which means they're not asking for a trial. They're saying the facts are so clear that a judge should rule immediately. Federal courts typically take 6 to 12 months to rule on summary judgment motions. But 3 judges have already issued preliminary orders suggesting they're taking these arguments seriously. One federal judge in the Northern District of Texas wrote in a preliminary opinion that the government's continued insistence on registration requirements for items that cannot be taxed raises serious constitutional questions that may require immediate resolution. Translation: this judge thinks the plaintiffs might be right. What do you think happens if federal courts rule the entire NFA registration system unconstitutional? Do you trust Congress to respect that ruling, or will they find another way to control these items? Drop your prediction in the comments. Senator Murphy's counterattack. Connecticut. Senator Chris Murphy introduced his counter-amendment exactly 72 hours after the permanent tax elimination passed, which tells you this wasn't a spontaneous response. This was a coordinated strategy that was already prepared and waiting. The amendment proposes raising the NFA transfer tax from $0 to $5,500 per item, the manufacturing tax to $5,500, and creating a brand new $750 annual registration fee for items already in the NFA registry. The original 1934 NFA tax was $200, which in today's inflation-adjusted dollars equals approximately $4,600. Senator Murphy's proposal actually exceeds the inflation-adjusted original tax, making it the highest tax burden on constitutional rights in American history. Murphy wants to impose a tax that's 6 to 13 times higher than the actual cost of the item itself. But here's the truly insidious part: the $750 annual registration fee. This isn't a one-time tax. This is a perpetual annual extraction of wealth from gun owners who already paid $200 for items they currently own. There are approximately 5.2 million registered NFA items currently in civilian hands in America. If Murphy's annual fee passes, that's $3.9 billion per year in new federal revenue extracted exclusively from gun owners. That's not a tax. That's a confiscation scheme disguised as regulation. And the timing of this amendment reveals exactly why they're panicking right now. Why the timing exposes their desperation. Senator Murphy introduced this amendment during the fiscal year 2026 appropriations process, which is the exact same legislative mechanism that was used to eliminate the tax in the first place. This reveals something critical. They know that if they tried to pass this as standalone legislation, it would die in committee. So they're trying to bury it inside a massive 2,000-page spending bill that most members of Congress won't even read before voting. The appropriations bill Murphy chose has a hard deadline of March 28, 2026, or the federal government shuts down. Leadership from both parties are under enormous pressure to pass something, anything to keep the lights on. Murphy is gambling that, when it comes down to the final hours before a shutdown, enough Republicans will cave and vote for the spending package, even with his NFA amendment attached. Here's the data that should alarm everyone. In the last 6 major appropriations fights that went down to the wire, an average of 18 Republicans broke ranks and voted for bills containing provisions they publicly opposed, citing the need to keep the government functioning. Murphy has done the math. He knows the playbook. He's counting on political cowardice and shutdown fear to ram through the largest gun control tax increase in American history, without anyone even debating it on the floor. But what's happening in federal courts right now might make Murphy's entire strategy irrelevant. The 3 federal judges who could end this. 3 separate federal judges in 3 different circuits are currently considering motions that could strike down the NFA's registration requirements entirely. And all 3 have issued preliminary rulings that suggest they're sympathetic to the plaintiffs' arguments. Judge Reed O'Connor in the Northern District of Texas, Judge Matthew Kaczmarek in the Western District of Texas, and Judge Catherine Kimball Mizell in the Middle District of Florida have all issued orders allowing these cases to proceed on an expedited basis, which is extremely rare in Second Amendment litigation. Judge O'Connor wrote in a preliminary order that when Congress eliminates the tax that forms the constitutional basis for a regulatory scheme, continued enforcement of that scheme may constitute an ongoing constitutional violation, requiring immediate injunctive relief. If O'Connor grants the preliminary injunction that plaintiffs are requesting, it would immediately block the ATF from enforcing any NFA registration requirements in Texas. And because of how federal injunctions work, that order would likely apply nationwide within days. The government is terrified of this outcome, which is why the Department of Justice filed emergency motions in all 3 cases, asking the judges to delay any rulings until after the appropriations process concludes in late March. They're not even hiding their strategy anymore. They're openly admitting in court filings that they need time for Congress to reinstate the tax before judges can rule on whether the tax is constitutionally necessary. The DOJ is telling federal judges, please don't rule on this yet, because Congress might change the law to make your ruling unnecessary. That's an admission that they know they're going to lose on the current facts. If a federal judge strikes down NFA registration requirements nationwide, do you think the ATF will actually comply and stop enforcing them? Or will they ignore the court order and keep arresting people anyway? Let me know what you think. The Trump DOJ's betrayal. Attorney General Pam Bondi's Department of Justice is actively fighting to preserve the NFA in all 15 of these federal lawsuits, even after Congress permanently eliminated the tax. The DOJ's legal position is that the NFA doesn't need the tax to be constitutional because it can be justified under the Commerce Clause, under general police powers, and even under the Second Amendment itself through intermediate scrutiny analysis. This directly contradicts what 41 members of Congress, 5 senators and 36 representatives, told Bondi in a formal letter where they explicitly stated that Congress's intent in eliminating the tax was to eliminate the registration requirements as well. Here's the specific language from that congressional letter. Congress affirmed its position that the taxation and registration provisions of the NFA are inseparably linked, and expressed its intent to repeal the NFA's registration and transfer requirements by eliminating the associated taxes. That's not ambiguous. 41 members of Congress are telling the Attorney General directly what Congress meant when it passed the law, and she's ignoring them. She's substituting her own interpretation of congressional intent for the actual stated intent of the people who wrote and passed the legislation. The DOJ has spent over $8.2 million in legal fees defending the NFA in these 15 cases over the past 4 months. That's taxpayer money being used to fight against the express will of Congress and against the constitutional rights of American citizens. The betrayal is stunning, but there's a financial angle to this that explains why the DOJ is fighting so hard. The real reason: the government won't let go. The National Firearms Registration and Transfer Record, the NFA Registry, contains detailed information on 5.2 million suppressors, short-barreled rifles, short-barreled shotguns, and other NFA items, including the names, addresses, and fingerprints of every person who owns them. This database has become the federal government's most comprehensive gun owner registry, and they've been using it for purposes that go far beyond the NFA itself. When ATF conducts investigations into potential straw purchases, potential prohibited persons, or potential trafficking operations, they routinely cross-reference the NFA registry to identify gun owners in specific geographic areas. The ATF's own internal guidance documents, obtained through FOIA requests, explicitly instruct field agents to utilize NFRTR data to identify potential sources of firearms in ongoing investigations, even when those investigations do not directly involve NFA items. They're using the Suppressor registry to investigate people for crimes that have nothing to do with suppressors. They've turned the NFA registry into a general gun owner database that they mine for investigative leads. There's also the international angle that nobody's discussing. The United States has information sharing agreements with 17 foreign governments, where we exchange data on gun owners who travel internationally or who have business connections to foreign nationals. The NFA registry is a key component of these information sharing arrangements. If courts eliminate the registry, the U.S. government will no longer be able to provide foreign governments with information about American gun owners, which could affect everything from extradition treaties to international law enforcement cooperation agreements. But Murphy's amendment includes a provision that would make all of this irrelevant. The poison pill nobody's talking about. Buried in Senator Murphy's amendment on page 47, subsection D, there's a clause that would retroactively apply the $5,500 tax to every NFA item currently in the registry, with the tax due within 180 days of enactment, or the item must be surrendered to ATF for destruction. This isn't just a tax on future purchases. This is a retroactive wealth extraction scheme targeting the 5.2 million NFA items already legally owned by Americans. If you currently own a suppressor that you bought 5 years ago and paid $200 for, you would owe the federal government $5,500 within 6 months or turn in your suppressor to be destroyed. The Congressional Budget Office hasn't scored this amendment yet, but independent analysis suggests it would generate between $18 billion and $26 billion in one-time revenue if only 70% of current NFA owners pay the retroactive tax instead of surrendering their items. This would be the largest single gun control revenue generation scheme in world history. For comparison, Australia's mandatory gun buyback program in 1996 cost their government approximately $230 million in 2024 dollars. Murphy's proposal would extract 100 times more wealth from American gun owners than Australia's entire confiscation program cost. But here's the truly evil part. Murphy knows most Americans can't afford to pay $5,500 per item within 180 days. The average NFA owner possesses 2.3 registered items, which means the average person would owe $12,650 to keep items they already legally own. For families that own multiple suppressors for different calibers, or collectors who own several short-barreled rifles, you're looking at tax bills exceeding $50,000 or more. Murphy is betting that most Americans will surrender their items rather than come up with 5-figure tax payments on 6 months' notice, which would effectively eliminate millions of NFA items from civilian hands without compensation. Do you think this retroactive tax scheme could survive a legal challenge under the Takings Clause and due process protections? Or is this just political theater that Murphy knows will never actually become law? Share your legal analysis below. That's the current state of the fight over NFA taxes and registration requirements. Things are moving fast in both Congress and federal courts, and what happens in the next few weeks will determine the future of suppressor and SBR ownership in America. Subscribe now and turn on notifications so you don't miss critical updates on this developing situation.